Welcome everyone to the panel on religion and public reasoning. We are 3 people speaking on this panel instead of 4, which allows us to have lots of time for a truly engaged conversation. And we thought in order to foster that, each member of the panel will speak and we will have some questions after each paper, and then we will have reactions and conversation about the panel as a whole. I'm going to introduce everybody individually rather than read everyone off right now. And we will begin with first listed participant, Professor Gila Stopler of the College of Law and Business.
Okay. Thank you all for being here, and thank you, Yossi, for inviting me. The topic, since we're in a panel about public reason, I want to address my my talk to how public reason interacts with women's rights. And what I want to do in my short talk, and I have to apologize, I thought I was supposed to, prepare a 15-minute talk, so that's what I did. My talk is going to be somewhat shorter than the preceding ones. So in my short talk, I want to question the usefulness of Rawls' idea of public reason for the advancement of women's rights. And I want to do that by discussing an example from the recent Israeli elections. As you all know, there's been an election in Israel just a few days ago. So at first glance, I think that the idea of public reason seems to be very attractive for secular feminists who are concerned with the effects of patriarchal religions on the rights of women. After all, Rawls' idea of public reason suggests that reasons that are based on particularistic religious beliefs and that cannot be understood by citizens who do not prescribe to these beliefs cannot be considered public reasons and cannot legitimately justify the state coercion of those citizens. So allegedly pursuing the idea of public reason would allow us to exclude a whole host of patriarchal religious arguments from the public sphere, thereby making the feminist task of opposing state action that discriminates against women easier. However, what I wish to argue is that to the extent that the idea of public reason and liberal public reasoning in general excludes religious arguments from the public debate and from public scrutiny, it may actually harm women's rights more than it protects them. This is because the idea of public reason is another manifestation of the liberal refusal to entangle the liberal state with religion. Because the idea of public reason is part and parcel of the liberal respect and deference towards religion. For this reason, the idea of public reason merely serves to entrench religious patriarchy rather than to dismantle it. It's particularly unhelpful in the context of the religious resurgence that this conference is trying to discuss and which the world is experiencing. So Rawls explains the idea of public reason by arguing that when a state, as a political system, coerces citizens, it must justify the coercion by using reasons that these citizens, as free and equal persons, can reasonably accept. Now, this is a very attractive argument, obviously, for feminists, and I'll return to that argument at the end of my talk. However, what I want to claim is that this is not the only reason why Rawls opts for the exclusion of religious ideas from the public sphere. Another very important reason, to my mind, is that as a liberal, and even more so as a political liberal, Rawls adamantly refuses to evaluate religions. Liberals justify their refusal to evaluate religions by relying on several core liberal concepts. These concepts include, for example, the importance of state neutrality, the significance of showing respect for individual autonomy, the centrality of the division between the public and the private sphere, And with that, the assumption that removing religion from the public sphere and relegating it into the private sphere sufficiently protects women, in this case, or any other group, from a violation of their rights in the public sphere, which is obviously the main sphere of interest for liberals and certainly for political liberals. Now, for all these reasons, Rawls refuses to evaluate religions and to entangle the state in religious arguments. He prefers to restrict religion's participation in the in the political sphere by erecting a supposed barrier in the form of public reason. However, I want to argue that this form of liberal public reasoning creates two problems. First of all, if the purpose of the idea of public reason is to ensure the basic rights of free and equal citizens by preventing state coercion that is based on particularistic, comprehensive doctrines, then this idea has no real teeth. It's exceedingly easy to sidestep, and I'll show it in a minute. And second, and more importantly, and perhaps paradoxically, the end result of the liberal public reasoning, which refuses to confront religions and to challenge their discriminatory aspect, is not their exclusion from the public sphere, but their uncritical adoption as a justification for continued discrimination against women. So perhaps unwittingly, public reason serves to entrench the power of patriarchal religious leaders and further disempower women who are trying to challenge them. So in order to make my point, I want to take as an example, as I said, the last elections in Israel. As you all know, probably know, there was an election last Tuesday. In 2 out of the 10 parties that have entered Israeli parliament, there are no women representatives. There were 3 parties that had no women representatives, but one of them didn't succeed into getting into parliament. Neither of these parties have ever had a woman representative. Their leaders openly admit that this lack of representation is intentional, is the result of a prohibition laid down by religious sages, which are the spiritual leaders of these parties. And these 2 parties that did enter parliament, Shas and United Torah Judaism, are both, and the third one also that didn't enter parliament, they're all religious, the Jewish religious parties that represent the ultra-Orthodox or Haredi community in Israel, as well as a considerable number of Orthodox Jews. According to their view, their prohibition stems from the halakha, which is the Jewish religious law, and from those precepts that forbid women to hold public leadership roles, from precepts requiring them to abide by rules of modesty. Now, in the last 2 years, several very brave Haredi women, and I'm emphasizing very brave, have started objecting to the lack of representation in Haredi parties. And they've started to demand representation in these parties. They've approached the Haredi parties, demanding that they appoint a woman, any woman, not necessarily themselves, but any woman, as party representative, but they were flatly refused. And now, consequently, they filed a petition to the Israeli Supreme Court, asking the court to withhold election budgets from Haredi parties due to their discrimination against women. The Supreme Court summarily denied the petition. And this denial actually follows previous denials or previous failures by these women. A similar petition was filed to the Supreme Court a year ago regarding municipal elections. This one also failed. 2 years ago, in Israel we have elections every 2 years, so in the national elections 2 years ago, there was a petition filed to the Central Elections Committee to disqualify these parties because they don't represent women. This, by the way, was filed by non-Haredi women. The Central Election Committee denied that, the petition. Neither the court nor the Central Elections Committee gave reasoning in this case. And After this most recent denial, the Haredi women decided to establish their own party because they saw they have no recourse in entering established parties, and they tried to run for parliament in these elections, for national parliament. And as part of their election campaign, they wanted to advertise an ad in the Haredi daily newspapers. All Haredi daily newspapers denied them their ad. And I want to remind you that Haredi newspapers are the main source of information for the Haredi community because many of them do not have television and are not allowed to follow Facebook, internet, whatever. So because all Haredi newspapers refused to publish a campaign ad, they again applied to the court against the largest Haredi newspaper, Yated Ne'eman, in order to, and filed for an injunction to make the newspaper publish their campaign ad. The lower court decided in favor of the Haredi Women's Party, issued the injunction, but this decision was immediately overturned by the Supreme Court, allegedly on technical grounds. And the end result was that the Haredi Women's Party did not publish any campaign ad, and they got very few votes in the elections. Obviously, they would have gotten very few votes even if they had published the ad, but this was definitely didn't help their case. So in all the aforementioned cases, the Haredi parties and Haredi newspaper, which I will now call all of them the Haredi patriarchal leadership, repeatedly claimed that the women's attempt to run to the Knesset and to promote the women's right agenda was contrary to the community's religious precepts. So in all these cases, the court and the Central Elections Committee evaded any substantive discussion of this claim, but they repeatedly ruled in favor of the Haredi patriarchal leadership. And their continuous rejection of the women's petitions clearly indicates that they have accepted the Haredi leadership position and have consequently simply opted not to intervene in favor of the women, in effect countenancing their continued oppression. Now, what does all this have to do with the idea of public reasons? So first of all, I think that it's clear that the political parties that participate in national elections, whose representatives are called upon as members of parliament to decide fundamental political questions that sometimes coerce the entire society, should be seen as part of what Rawls calls the public political forum, and not as part of the background culture. However, what I want to argue is that in the way that these cases turned out, demonstrates that liberal public reasoning, as it's currently understood, is not only unhelpful, but it's actually harmful to women who are attempting to struggle against the discriminatory effects of patriarchal religious precepts. And I will discuss the 2 points I made earlier in the context of this case. So first, it's true that the idea of public reason would prevent, in our case, the patriarchal religious leadership from claiming that they're excluding women from their political parties because God has forbidden women to run for public office. Such reasoning would obviously not would be based on a particularistic, comprehensive religious doctrine, which is only intelligible to those people who subscribe to that doctrine, and it would therefore be not be considered public reason. But aware of the problematic nature of such a type of claim, what the religious patriarchal leaders have claimed in all these cases was that it was their sincerely held religious belief that their religion prohibits women from running to public office, and that if the court supported the women's claim, it would infringe on the Haredi community's autonomy, it would infringe on their religious freedom. Now, framed this way, the exact same argument, but framed in a different way, makes the religious leader's claim compatible with public reason. Not only compatible with public reasons, but also because in liberal theory, autonomy and religious freedom have fundamental importance, such claims have a very large weight. Okay? So the only thing that the patriarchal religious leaders need to do in order to bypass the barrier of public reason would be to make sure that instead of claiming that God has ordained a certain practice, they would claim that it's their group's sincerely held religious belief that that practice had been ordained, and that any imposition to the contrary would be a violation of their autonomy and religious freedom. But second, and an even more serious shortcoming of liberal public reason seen in these cases is that the structure of public reason prevents the courts from questioning the religious patriarchal leaders' assertion that prohibiting women from running for public office is indeed a central tenet of their religion. And it also prevents the court from questioning whether such a tenet, if indeed central, is justifiable. This is because Rawls emphasizes that political liberalism does not trespass upon religious beliefs. It does not trespass upon religious injunctions of reasonable religious comprehensive doctrines. And as feminist critiques such as Okin, for example, have pointed out, Rawls does not view patriarchal religions as unreasonable doctrines. If he would have viewed patriarchal religions as unreasonable doctrines, he would have to disqualify a whole host of very popular religious doctrines, and this is probably the reason why he doesn't view them as unreasonable. However, if in the case at hand, courts were more willing to scrutinize the assertion of the patriarchal religious leaders, the courts would have realized that there are halakhic views holding that there is no prohibition against women running for public office and serving as parliament members. Religions are not monolithic. For almost any view you can see, you can find views supporting supporting the contradictory view, and in fact the Haredi women who are engaged in this struggle are themselves relying on halakhic views. So these women are not saying, you know, we have to change the halakha or the religious law. They're saying the religious law has many interpretations. Here you have an interpretation which goes with our view and not with the religious patriarchal leadership view. So my claim is simply that the structure of liberal public reasoning, as it currently stands, helps shield the leaders of the patriarchal religious groups from any challenge to their discriminatory leadership. This must be changed. So the courts should stop being afraid of entangling themselves with religion. They should scrutinize religious arguments, both to determine whether the religious doctrines invoked are indeed as set in stone as the religious leadership would have the court believe, and in order to reject religious arguments that are discriminatory. If, as Rawls insists, the motivation behind his theory in general and behind the idea of public reason in particular is to ensure that the state treats all citizens as free and equal, then the way to achieve this in a world in which religion is becoming more and more important is for state institutions such as courts to purposely entangle themselves in debates regarding religious dogma and deliberately give preference to those religious ideas that promote rights over those that violate rights. Thank you.
I'm going to open up this very provocative paper for comments.
I mean, one of my questions is, you question this notion that the religious groups, you say they can just get around non-discrimination norms by asserting that they have a sincere religious belief. One of my questions is, do you question the sincerity of their beliefs? Because on the one hand, I think, I don't think any system has a lot of interest in protecting insincere religious beliefs. So that's my question. But I assume, and I'm not sure I know the word you're using, haladi, or I'm not going to get it right, but presumably conservative religious groups have this belief. Now you say that there are other halachic beliefs. Do these groups hold those other halachic beliefs? I assume they don't hold the other ones. So I'm assuming that the situation is one in which you've got a religious group and I'm asking because I might be wrong. I mean, you might really have some cases where you've got absolutely sham religions or something like that, but I don't have the sense that that's what's going on here, that you have a sincere religious belief that may be a disputed belief within Judaism as a whole, but for these groups, it's a sincere belief. It's a little bit like the headscarf issue for women, and there are debates about whether you need to cover, but if you're a sincere believer, do you have a right to wear a headscarf, or should some others sort of dictate to you that you shouldn't, or do you protect the women because you're afraid that they're being coerced? So the question is, what do you do with if it is a sincere belief, and why shouldn't that sincere belief have as much right to respect as your counter belief that they shouldn't? And how do you it seems to me that what you're asserting will result, it may help some women, but it will result in the discrimination against the men in these groups. So how does that get justified?
Okay, so thanks for the question. I think it's a very good one. So I have what to my mind seems an easy or an easier case. Okay, do I question the sincerity of their belief? No. I don't think I have any, any reason to question it, because in the facts of the case, it's irrelevant. Why is it irrelevant? Because these specific women are Haredi. So you have the individual, like the veil. You have the individual question whether an individual has a sincerely held religious belief that they want to wear the veil, and then obviously they want to wear it. It's their individual sincere belief is important there. But here we have a group, and the group has, again, the group is not monolithic. These Haredi women are from within the group, even though it's always, again, it's very easy for the group leaders to come and say, they are not Haredi at all. And we have many instances of that saying, and they actually also said that in this case, but in previous cases in which women challenged anything that's violates their rights within the group, then the easiest way out is to say, well, these aren't Haredi. We all believe in that. So their belief might be sincere. Actually, I have to, again, it's all about, it's just like in the previous panel, and I'm sorry that I'm very, real politics. It's all about politics. So one of these groups, Shas, for example, which is the Mizrahi ultra-Orthodox group, there's the daughter of Ovadia Yosef, who was the spiritual leader, like the greatest spiritual leader of the ultra-Orthodox, at least the Mizrahi ultra-Orthodox of this age. He died recently, about 2 years ago. His daughter is a very, very known woman within Haredi ultra-Orthodox circle. She wanted to run for parliament. She wanted to have a seat in the Shas movement. And the leader of the Shas movement, knowing full well that it's not that there's an explicit halachic, negation of the possibility, but that politically it would not be wise at the moment, told her something like, just wait a little, maybe in the next elections. So it's always this thin line between sincerely held religious belief and political maneuvering, which again the law has no way of, it's difficult for the law to come and say, you're insincere or you're not insincere. And in this case, again, you have very many religious interpretations. The halachic interpretations that these women are, supporting, they're not outsider interpretations. They are interpretations from within. So again, it's very, for us, we always look at religion and say, well, you know, religion is this. You have it in the books. But you have many books, and the books say different things. And the question is, what should the state support? Should the state support this interpretation, or should the state support that interpretation? What's convenient for the state currently to do is to say, you know, well, this is the interpretation that the leaders say is the one that we need to support, so that's what we'll do. We don't want to entangle ourselves in religious debates. What I'm suggesting is that this is not the right way to go about it. That if a liberal state is indeed committed to freedom and equality, it should vote for or opt for the interpretation that promotes women's equality. Now you say, what about discrimination against these men? I don't think that's discrimination against these men. Okay, so I think it's. They're not going to be able to follow their views the same way that women would. Well, you know, so again, we go to reasonable and unreasonable. If we go back to Rawls' distinction between reasonable and unreasonable comprehensive doctrines or religious comprehensive doctrines, he says unreasonable comprehensive doctrines, like racist comprehensive doctrines or of this sort, shouldn't be even, you know, we shouldn't even, they should be completely excluded from the public sphere. Now, what's the reasoning? The reasoning is that if you have a doctrine which, you know, from the start discriminates against somebody, devalues someone, says you are not allowed to be, to do this and that which I am allowed to do, then you should just discount it. It's not a valid. It's not a valid doctrine. So I don't think you can argue. It's like Mill said, you know, that the person who steals the purse from somebody doesn't have the same right, the same freedom or the same right to claim that somebody is interrupting his stealing as the person who is stolen from. People do not have this. People who want to discriminate against somebody do not have the same right to claim non-discrimination as those who are discriminated against. And because discrimination against women was there first, doesn't mean that they should get, you know, ascendancy, or that they should be superior, or their claim should be superior to that of the women who come and say, you know, you could interpret religious otherwise, the religion otherwise. There are completely legitimate, recognizable ways of interpreting the religion otherwise. And in that respect, I think the state is obliged to help the women and not the patriarchal leadership.
Okay, so first of all, thank you for a very interesting presentation. And I will take up from the last comments. I think we all know that the state really has a very strict line which it does not allow to cross in many religious customs. I mean, we do not allow female genital mutilation, right? I mean, it's no problem, even if it is halachically or divine law decreed that it must be done, and there is no other interpretation. No, the state will not have it. So really, maybe the question is, not only is there other views in the religious law that we can base upon another account of the process, but really, where does the state draw the line? And I think in this instance, the state or the courts held that it is not too extreme an exercise to disallow women to enter into politics in ultra-Orthodox parties. We can agree or disagree, but maybe the point of argument is whether this is supposed to be indeed the limit that the state wishes to enforce, or can the state really humor this little quirk or a custom that the ultra-Orthodox have?
Yeah, so I agree that that's you can rephrase the question on these terms. the only question is, these women, these Haredi women are citizens just like the Haredi men who stopped them from running into parliament. So I don't know why the state should humor them and not the women. I wouldn't want the state to humor somebody who wants to discriminate against me, okay? And the state, regularly the law does not humor people who want to discriminate. Religion is different, and that's the problem. I think there are some good reasons to treat religion differently, but I don't think that in this respect it should be different. The law shouldn't humor people who want to discriminate just because they say that they are religiously motivated. Or at least it should not be so, unhelpful. So it should not come and say, "Oh yeah, well, you say it's religion, then we're not going to interfere." It should be much more. The state should be much more willing to interrogate, to go into these practices, and say, for example, you could have, there are other halachic views. So you are entitled to your halachic view, but we as a state, because this is a political party, because it runs into parliament, because eventually these people decide for the all of society, and because they decide for their group too, we're not going to humor you on this point.
So I'm looking at the time, which is my job, and I'm worried about giving everybody. What I would like is perhaps Jose, Brett, and Tahir formulate your questions, but refrain from responding to each one individually. Maybe just say something about that, and then we can keep them and mark them and use them at the end of the discussion so that everyone has the same tough questioning that you're getting. Professor Casanova.
I could also skip and just wait for the final, for the general discussion. I like your presentation very much, and I understand that you're a Rawlsian, interested in advancing Rawlsian arguments, but what do you need the Rawls here? I don't think that the Israeli state or the Israeli courts use Rawlsian arguments. The fact that we have already religious parties. So the very notion that this distinction between secular public reason and religious particularistic religion is not accepted by the Israeli state. It's not a foundation. So, I fully agree with everything you've said, but just forget about Rawls. Rawls is irrelevant.
I have only to seek briefly some information from you. I know that Israel doesn't have a constitution yet, but you do have a basic law on human rights and dignity. What that law has to say about it? Does it approve the religious attitude towards the discrimination against women, or is it silent on it? And does it conflict with the Universal Declaration of Human Rights on this point?
So I'll try to be brief as well. My question has to do with whether the failure you sense in this example is a failure of public reason, or whether it's a result of a balancing of rights that you don't like. And so, for example, it seems to me that public reason allows us to criticize the religious parties just as you have done for being discriminatory, for being unfair towards women and so forth. It seems to me that what we have here is a clash between the rights of those women who want to participate in this party with rights of association and with freedom of the press. And so in the first situation, when they say you ought not fund this party, the state's response was to say, look, we don't want to get into the business of deciding who a party chooses as its candidates. That's a matter of freedom of association, and the state ought not be involved in telling political parties who their candidates can or cannot be. And when it comes to the newspaper, it seems to me that the Israeli court was saying freedom of the press, freedom of speech means that we should not require a newspaper to accept an advertisement contrary to their basic editorial judgment. And so we can imagine, for example, the Women's Voice Party, and some women in that party believe that there should be some men allowed as candidates, but others think it should be exclusively women. And the question is, do you really want the state to be the person to mediate that dispute within the group? Or if you had a feminist newspaper and the Halidic group wanted to run a party saying that you were sinful and we're all going to go to hell, I mean, we might want to say, we want that newspaper to be able to refuse in their editorial judgment receiving that advertisement. So it seems to me that the disappointment here is a result of the vindication of the rights of association and the rights of speech rather than a failure of public reason.
Yeah, so I had 3 questions. I'll respond to all of them at once. I'll just remind you, Jose said that Rawls is irrelevant, and Tahir's asked me what the legal situation is, and Brett said that it's just a question of balancing rights. And actually, I'll take all of them together. The legal situation in Israel is that we have the basic law of human dignity, and liberty, and that basic law would just say, you have what you have here is the balancing between 2 rights. One of them, religious freedom and freedom of association, and the autonomy of the community, and the other one is women's equality. And my claim is, and this is where Rawls does come in, and here I criticize Rawls, and not just Rawls, but liberalism in general, that once this comes in, once you have the autonomy, the religious freedom, the community, you only hear one voice. And that's the voice of those leaders of the community who come and tell you, you see, this is our religion. And once they say that, this is taken as a given because liberalism would not go any further into investigating religious claims, because investigating religious claims is outside the scope of public reason. And that's my claim. So my claim is this is the point in which the court needs to say, well, wait a minute, or the court or the legislator or whoever needs to say, wait a minute, there are more ways of understanding this religion than one, and therefore we are taking it upon ourselves to choose, to actively choose the one that's less discriminatory for women. So this is what I,